SJC-10301, BPR Group Limited Partnership versus Bendetson.
Good morning, Mr. O'Connor.
Good morning, Your Honor.
You may proceed.
May it please the Court, Thomas N. O'Connor for the Plaintiff Appellant, BPR Limited Partnership, and with me is David Mack. We're asking this Court for three things. First, we're asking this Court to reverse the Superior Court's legal determination that the three joint venture agreements here at issue were not at will, and rule instead that the joint venture agreements lacked a definitive term or a particular undertaking, so that BPR's notice of dissolution was appropriate under Chapter 108A, Section 31B1.
Well, let me ask you something. Where in Section 11 does it say that, which talks about termination, that this was an at-will arrangement?
It doesn't specifically say that, Your Honor. What it doesn't include is a date or a point of termination or any temporal circumstances under which the partnership would otherwise terminate.
Well, in Section A, 11A, this joint venture shall terminate upon the first to occur of the following events. Doesn't that set a time frame?
That does not, Your Honor, particularly if you
One of these four things has to occur to terminate.
well, the case law, and specifically the Trupiano case under the First Circuit and the Gradient Bank case out of Pennsylvania, both dealt specifically with this similar issue where there were termination provisions inserted into a partnership agreement.
But isn't that really a misreading of the First Circuit case? Because what the court said was, after '94, it was clearly an agreement at will, because the termination date had passed.
But
So, I mean, it seems to me it's a different kind of case.
with all due respect, the modification agreement provided specifically that it could be terminated upon a 60% vote of the partners.
Yes, but then '94, whatever that year was, came and went, didn't it?
Yes, Your Honor, it did. It expired. So the post-expiration termination provision would have been only, as far as the limited partnership agreement was concerned in that case, would have been the 60% vote by the partners. And we don't have anything in any of the four sections in Section 11 in these limited partnership agreements which puts any time limits or any temporal circumstances. The cases have held that a partnership agreement for the acquisition, development, and operation of specific real property, even specific limited real property, is not in and of itself a definitive time period or a particular undertaking sufficient to make the limited partnership agreement anything other than at will.
So there's the unspoken, there's a fifth category for termination that's not written in Section 11, but we should read into it that says that this is at will and can be terminated at any time.
No, Your Honor. There is a statute which specifically gives every partner the absolute right to dissolve a partnership.
I'm talking about Section 11 here. It talks about the four occasions that shall terminate upon the first to occur of the following events. We should also see a fifth category, which is at will.
No, Your Honor. That's not our argument. Our argument is that the statute itself, which provides every partner in a partnership with the absolute right to dissolve the partnership, be it in contravention of the agreement or consistent with the agreement, provides specifically that if the partnership agreement does not have a definitive time or a particular undertaking.
Definitive term. Are you taking term to mean time?
Excuse me, Your Honor. The definitive term is the actual language, yes. And I believe that the cases have specifically held that what they're talking about in terms of a definitive term is a specific time frame. Or a particular undertaking. And a particular undertaking there have been a number of cases that have held specifically that in connection with single asset real estate development, if the purpose of the limited partnership agreement is the acquisition, operation, and development of that real estate, that is not sufficiently temporal, it is not sufficiently particular to constitute a particular undertaking. Since this particular these three joint venture agreements do not have a term and do not have a particular undertaking within the meaning of the statute, these three joint venture agreements were for purposes of the dissolution statute
I understand.
at-will limited partnership agreements, which means that when BPR Limited Partnership gave its notice of dissolution, it did so under Section 31(1)(b). Now, there's consequences to that in terms of the actual damages, because if the limited partnership agreement is terminated by a partner in an at-will context, that partner gets the right, at the end of the day, to what's called a liquidation value. You take the assets of the partnership, you subtract out the liabilities. In this case, BPR was a 25% partner. That partner, the BPR would be entitled to 25% essentially of the net. If you terminate or dissolve, not terminate, if you dissolve a partnership in contravention of the partnership agreement, that meaning to say, if it wasn't an at-will, let's say it was for a term certain, and you as the partner dissolved the partnership prior to the expiration of the term, you're in breach of the partnership agreement. The contractual relation between the parties was going to be a certain time. You've breached the contract now.
If you do that, though, but I mean, and I understand your argument that you didn't, but assume that one might agree with Judge Van Gestel that you did. Doesn't the, is it Anastos?
Anastos case.
Doesn't that really govern what happens thereafter?
It does, Your Honor, to a large degree, absolutely. We have an argument on this interest calculation down the road, but clearly the Anastos case says that if you terminate a partnership in breach of the partnership agreement,
and the partners want to continue,
and they want to continue,
then you've got this going concern measurement.
Correct.
And it seemed to me that it also governs the interest, doesn't it?
well, our situation, I think, is quite frankly materially different on the interest issue than it was in Anastos, because here what happened was Judge Van Gestel ruled that BPR must not only disgorge what it received after the notice of dissolution, but then refuse to award interest on the amount that it was entitled to receive nunc-pro-tunc. So we got, to some extent, a little whipsawed on the interest issue, because on the one hand, we had to give back what we had received under the partnership agreement.
But you didn't have to pay interest on that, did you?
No, we did not have to pay interest on that, correct. So in that sense, I do agree with you that the Anastos case, assuming this court finds that there was a dissolution in violation of the partnership agreement, or was not otherwise permitted under the judicial dissolution section that we argue as well.
Oh, could I ask you a question about that?
Certainly.
It seemed to me that at end of partial summary judgment number 1, Judge Van Gestel said, all I'm doing is saying that this was dissolved, but the BPR is free to pursue that this was a dissolution under Section 32C, D, and F, I think, if I've got the right letters.
That's correct.
So F is the one you're talking about now.
Yes, Your Honor.
The next thing that one sees in the record is the next decision on a partial summary judgment, and there is no mention whatsoever about that. So I'm wondering, was there, and he let you pursue discovery. What happened? What did you do about that F between the first partial summary judgment decision and when Bendetson moved for the second partial summary judgment?
There was some discovery taken, and there was an opposition, obviously, to the second summary judgment motion, in which we argued specifically that given the disharmony and discord amongst, frankly, all of these partners. I mean, Bonato and Bendetson were fighting. Drucker and Carver were not talking to each other. They were brother-in-laws. There had been no meetings. There had been this awful August 2000 meeting where everybody shouted at each other. Everybody left. They never had another meeting ever after that. And our argument to the court was that raises a sufficient issue of fact on the issue of whether, under equitable principles, the partnership should be dissolved. And Judge Van Gestel essentially ruled, well, it doesn't fit in any of the categories above subsection F, and therefore, since it doesn't fit in any one of those categories, I don't believe that there's a sufficient cause to dissolve the partnership. And our argument is that section F is in there for a purpose. It talks about other circumstances, and that the other circumstances are circumstances other than set forth in sections sub A through
E.
E. Thank you.
Let me ask you a question about the mortgage. During the period in which your client was participating in the joint venture became a mortgagor. Now, how do you justify your clients just dropping out of that?
Well, first of all, Your Honor, the mortgages came 18 years after the joint venture agreements were executed. So the argument that's being made here on behalf of the appellees is that they somehow are part of the joint venture agreements. And the law is pretty clear that since they weren't negotiated or executed contemporaneously, they're not part of the joint venture
No, but
agreement.
I'm asking apart from that. I'm not asking whether it adds a term, a definite term to the agreement. I'm asking how your client justifies just dropping out of the joint venture, and then when the mortgage says the dissolution is the dissolution is a breach of whatever it is, a default under the mortgage. So then how did your client justify its action?
Well, the joint venture agreements being at will gives each of the partners, all four of them, the right to dissolve at any time upon notice. In the
Despite
situ-
the terms of the mortgage?
Absolutely. And in the circumstances where a partner chooses,
The mortgage agreement.
no, he did not sign, my clients did not sign the mortgage
Or
agreement,
is
Chair.
it somewhere that all parties sign?
No, Your Honor. One, essentially the manager of the joint venture, Mr. Bendetson, he and his entities signed the mortgages. My clients did not sign the mortgages, neither did the other two partners. So what happens is you have a mortgage outstanding, you go into a dissolution by reason of the notice given by the partner. The properties could either be sold or the other partners could step in and pay the other partner, but it is going to be net of the mortgages. And that's obviously a creditor expense that is charged against what is otherwise going to be the top line or the assets of the partnership. You take the assets, you subtract out the liabilities, there's a net amount, and that gets divided in proportionate share of the limited partners, or the partners in this case. So what happened here was, because Judge Van Gestel ruled that the dissolution was in violation of the partnership agreement, we ended up trying the case under the Anastos criteria, and my client ended up with roughly half of what it otherwise would have been entitled to under a dissolution under an at-will set of joint venture agreements. And yes.
Let me ask you this. Going back to the first partial summary judgment, when he's looking at specifically at the at-will issue, his position is that if I go in the direction that you're advocating, then it makes Section 11 essentially superfluous. So tell me why, from your point of view, Section 11 is not superfluous if, in fact, one of the joint ventures has the right to dissolve.
It's not superfluous because those terms and conditions remain regardless of whether or not any of the partners decide to exercise their statutory right to dissolve. So, for example, none of the partners exercise their statutory right to dissolve. One of the partners go bankrupt. Those provisions apply because that's a contract between the partners to the partnership. Now, that doesn't mean that a partner in the partnership does not have the statutory right
I
to
understand.
dissolve.
And I'm probably with you with respect to 1, failed to perform obligations,
Right.
2, conveyance, 3, bankruptcy. But what about 4, by mutual agreement of all the members, doesn't that override, I mean, isn't that superfluous?
Well, Your Honor, I would argue that the analysis in the First Circuit decision is roughly equivalent to that same analysis. That is to say that when the parties contract for an agreement between the partners that may govern termination, or dissolution, that the statute itself, because dissolution is defined as any partner desiring to withdraw from the business of the partnership, that automatically, as a matter of law, constitutes a dissolution. Therefore, the fact that the parties may contractually have agreed to this particular methodology doesn't necessarily, and doesn't, as a legal proposition, preclude a partner from exercising its rights under the statute. And if the partnership agreement is an at-will partnership agreement, as we say it is here, because it's not for a definite term and it does not have a particular purpose, then the consequences of that dissolution are that the partner gets the liquidation value of the partnership. And that's the statutory construction.
Thank you, Mr. O'Connor.
Thank you very much.
Good morning, Mr. Zabin.
May it please the Court. It appears to us that this appeal raises two questions. And alternatively, the issue of whether the mortgage that was taken out was a 25-year mortgage, in effect would have made the contract between the partners, the joint ventures, a contract for a particular purpose. And in connection with that...
But how does a later document add a term to the agreement?
Because the agreement specifically had recognized that mortgages would be taken out. It was one of the paragraphs specifically stated that a mortgage could be taken out if the partners owning 75% of the equitable interest voted for it. Secondly,
Okay, but still, how does that add a term to the agreement?
the integration clause of the joint venture agreement provided for modifications, provided that it was agreed to in writing by all partners who would be affected by it.
Was it agreed
And
to?
here, I'm sorry?
Was the mortgage agreed to by all partners?
It was, and I do have to correct.
You said it was.
Well, I think
said
Mr.
signed.
Carnathan is incorrect. All the partners authorized in writing Mr. Bendetson to negotiate and sign the mortgage. Mr. Bernardo, in his deposition testimony, and you'll find that I believe it's record page 571, admitted that in doing so, he authorized Mr. Bendetson to go ahead and take out the mortgage. So our view would be that a sensible reading of the joint venture agreements, having in mind that they contemplated taking out mortgages, and that mortgaging and refinancing is an integral tool of real estate management, and that all the partners authorized Mr. Bendetson to act for them in taking out the mortgage, this has the practical consequence of modifying the terms of the joint venture agreements if they needed to be modified to enforce the contract that the parties agreed to.
So let me just play with that idea for a minute. If refinancing became necessary for some purpose, and one of the partners said, no, I'm not going to refinance, I want to stick to the 25-year term, would that partner be considered in default under the terms of the partnership agreement?
No, under the partnership agreement, there's no restriction on a partner voting no if more than 25% of the ownership interest votes no, the mortgage can't be taken out. But it requires a supermajority to take out the mortgage. And in this particular case, and this was not the first mortgage that was authorized, all the partners agreed.
You're not abandoning the rationale that Judge Van Gessler used, though, which was not that one, right? Are you?
No, I mean, Judge Van Gessel just didn't reach that. But nonetheless, we raised the argument, and that's, I believe it's on, you'll find that in the record at page 96. So the question is, does the text of the statute, Section 31, require that, in effect, the Section 4 and 11 of the agreements be invalidated? And we suggest it does not.
And you suggested for the reason that Judge Van Gestel reached, and even if you go to the particular undertaking, it's not an at-will for that reason.
Yes, yes. And basically, I think the statute is not particularly clear, but it says that essentially that a contract, that a partnership agreement that does not have a definite term is to be considered at will. What it doesn't say, of course, is that the definite term has to be measured only by the calendar. And we cited to the court in our briefs a short but I think well-reasoned decision from the New York Supreme Court Appellate Division, where it very specifically held that that partners may agree to limit the duration of their agreement, of their partnership, by the happening of a defined event. And in this case, the events that were defined by the partners in their agreement are very clear, and they're very unambiguous. The real issue is what's meant by definite. We can take the definition that's provided by BPR in its brief at page 33. It defines it from one of the Webster dictionaries, one of many, as having distinct or certain limits, free of all ambiguity, uncertainty, or obscurity. There's nothing ambiguous, uncertain, or obscure about Sections 4 and 11 of these partnership agreements. If the court needs additional synonyms, there are plenty of them. One is precise from the online Webster's Merriam Encyclopedic Dictionary, and if we want to go back to an ancient one, as ancient as I am, in 1930, published in 1937, 15 years after the adoption of the Partnership Act in Massachusetts, the synonyms given for definite are clear and unmistakable, clear and unequivocal. And I think that by any fair reading of this agreement, though the termination terms meet all these definitions and synonyms. So as an aid to the interpretation of the statute, one ought to look at whether or not the kind of contract that we have here violates some significant public purpose. Throughout the briefs, throughout the arguments in the lower court, BPR has never been able to point to either Judge Van Gessel or to this court any significant public policy that would be contravened by keeping the partners to their agreement in this case. This court, in the case, I believe it is the Beacon Hill Neighborhood Association against Toscana Restaurant, defined the standard for determining whether a contract should be enforced or not. And it said that where laws are designed solely for the protection of the rights of private property, a party who may be affected can consent to a course of action which, if taken against his will, would be invalid. And this provision that issue here is clearly to preserve the interest as they saw them of the partners. The public has no particular interest that has been shown in this case to when or how these partnerships may be dissolved without penalty.
Mr. Zabin, may I ask you a question about the
Of course.
judge's holding that Section F, I guess it's 32F, doesn't apply because none of the preceding subsections apply? In other words, the other circumstances that might render a dissolution equitable somehow isn't in play if none of the specific circumstances in the sections above are present? Doesn't that
Well, I think
make no
that's,
sense?
I think that the last section, F, is clearly designed to be a catch-all in case one can come up with some recognized equitable reasons to dissolve the partnership. In this case, Mr. Bernardo never pointed to a single act that any of the partners did that were in breach of their fiduciary relationship.
And the judge makes a note of that, and I wouldn't be surprised if the judge were to conclude there were no circumstances under F that would
That's- yeah.
equitably require this. But I think he said, as I recall, that because the other paragraphs don't apply, then this doesn't apply either, which doesn't really seem right.
I'm not. I don't have it right in front of me, but I think that I think that that there could be equitable reasons to dissolve a partnership that didn't meet the earlier criteria.
Well, maybe I'm overreading.
In this,
what you're saying.
well, I think so, Mr. Justice Cordy. But I have to point out that these partnerships were successful by any measure. They produced profits or cash flows year after year, and Mr. Bernardo agreed to it. The fact of the matter is, the discord that was only from Mr. Bernardo. And if you look at the records, Mr. Drucker's deposition, which is on, I believe I think it's around 411. What he says was, yes, he had some family dispute with Mr. Carver, but it never interfered with their business relationship. And they weren't all screaming at a meeting. Mr. Bernardo was the only one who was screaming at Mr. Bendetson. Throughout this record, you will not find a single piece of evidence that suggests that any of the partners treated Mr. Bernardo improperly. You will not even find that he was ever treated discourteously.
Mr. Zabin, can I ask you, was there an attempt by Mr. Bernardo to have the partners, you keep calling them the joint venturers, all mutually agree to dissolve? Was that part of what he had attempted?
Well,
I mean,
what-
invoking 11.4? Did
If-
he attempt to go that by mutual agreement of the members?
well, I'm not sure if I
just
quite-
don't, it may not be relevant, but I just wonder whether prior to his doing this unilaterally, whether, relying on the statute, whether he had attempted to reach an agreement among the other members to dissolve.
There had been negotiations, and as I understand, at one of the negotiations, which was mediated by Owen Todd, the other parties did agree to the original demand, or not the original demand made to settle it, and then Mr. Bernardo had second thoughts about it. But in any event, what he did try to do, he did try to, at a luncheon with Mr. Drucker, one of the partners, he did try to persuade Mr. Drucker that Mr. Bendetson was, quote, a bad man, and engaged in what could only be called character assassination in an attempt to get Mr. Drucker to be, a quote, on his side. So there is no evidence at all that he was entitled to any equitable relief in under Section 32. I do want to point out that many courts, including this one, particularly in Shaughnessy, Meehan against Shaughnessy, footnote 7, have said that that Section 31, the General Laws, Chapter 108A, should be treated as a form contract which can be varied by agreement of the partners. And that's what we have here. They've made a sensible agreement that was fair at the time, that made business sense even at the time that Mr. Bernardo dissolved the partnership. And it should be enforced. With respect, I think we have covered the issue of the mortgage and our view of how it affects the contract. I believe that questions raised by the Tropiano case accurately point out what the First Circuit did decide. That case has no relevance to here. And in the case of Gerard Bank versus Haley from the Supreme Court of Minnesota, which Mr. Carnathan has cited again to the court in that case, in finding a partnership to be at will, said the agreement being otherwise silent, the provisions of the act will control, clearly implying that the court viewed the act, just as this court did, as setting forth a form contract.
Mr. Zabin, this is a minor point. In your brief, you refer to the fact that the mortgage had a very high, severe, disadvantageous prepayment penalty. Does that make any difference?
It does, Your Honor, because walking out of trying to walk out of partnership when the individual partners have subjected themselves to significant financial risk, and may, if dissolution were allowed, be called to answer to those risks, I suggest to the court is very close to, if not, a breach of fiduciary duty. And clearly, under those circumstances, Mr. Bernardo was not entitled to any equitable relief by the court. Just one point on the interest, on the defeasance fee as being a element of damages. And Mr. Carnathan, in his reply brief, says he was deprived of the chance to cross-examine and present contrary evidence. I have to point out that over 80 pages of the record of proceedings after the decision of Judge Van Gessel, never once did BPR raise the issue or ask for a hearing. The familiar rule that one cannot raise for the first time, evidentiary ruling at appeal, applies here. I thank you very much.
Thank you, Mr. Zabin.